Welcome to the Supreme Court of the United Kingdom, where we are hearing the appeal in the case of the Secretary of State for Health and others, and Servier Laboratories Ltd and others. We are currently hearing the submissions in response to the appeal presented by Mr. Turner, Queen's Counsel, on behalf of the National Health Service authorities for England, Scotland, Wales, and Northern Ireland. Mr. Turner.
May it please the court. Before the short adjournment, I was developing the point that all of the cases you've been shown are about giving effect to the point which has been settled in the operative part of an annulling judgment. And we were looking at the first of those cases, Asteris. If I may invite the court, please, to turn up Asteris, which begins on page 961 in the bundle. I wish to make a particular point to illustrate what I was saying there. And if you would go, please, to page 974 and look first at paragraph 19, which is at the foot of the page, you will see that there, in two of the cases then before the court, the Hellenic Republic was asking for the annulment of a regulation insofar as it fixed additional aid only for the 1983-1984 marketing year, and of a refusal by the Commission, after being called on to act, to take rectifying measures with respect also to other marketing years, the error found by that judgment to have been committed. Paragraph 20, in support of its applications, the Hellenic Republic claims the Commission failed to fulfill the obligations incumbent on it under Article 176. And then if you drop down to paragraph 23, the Hellenic Republic wasn't claiming that the regulation made was unlawful in any way, the one that was the replacement for the one deemed to have been unlawful. It was claiming that the judgment that had been made, the annulling judgment, put the Commission under an obligation not merely to replace the annulled regulation, but also to adopt other measures adjusting regulations, the annulment of which wasn't sought. And if you then go to paragraph 28, on the following page, 976, the court there said, this is immediately under the proposition that we have been considering, although a finding of illegality in the grounds of a judgment annulling a measure primarily required the institution which adopted the measure to eliminate that illegality in the measure intended to replace the annulled measure, it may also, insofar as it relates to a provision with specific scope in a given area, give rise to other consequences for that institution. And on that basis, the court then goes on in the following two paragraphs to say that the point of law which had been decided in the annulling judgment, that point had effects which should have led the Commission to behave in a different way, also in making regulations for different marketing years. So that the point here is that it is the authority of this annulling judgment which is being interpreted. Here the court is saying the point which was decided by the court in the annulling judgment had implications beyond that particular marketing year. The next case in the sequence is the Assi-Doman case, which Servier argues has been misunderstood by the Court of Appeal. And here Servier's argument was simply stated in their written case at paragraph 89. If the court would look at paragraph 101 on that, page 101, paragraph 89, you will see that they describe that case as not being a case about borrowing facts found in one context for application in another, but a case in which the applicant sought to rely on findings of fact about the conduct of the non-Swedish producers to prove similar but distinct factual propositions about the Swedish producers. They failed because the court in Woodpulp 2 had not made any findings of fact at all about the Swedish producers or their conduct. That submission is incorrect because the Court of Justice did make findings in respect of those facts, which were common facts. The point of distinction was not the scope of the court's findings of fact. It was the ambit of the operative part of the annulling judgment. It was the interpretation of what was the authority of that court's annulment decision. And the point is that this competition case was different in its nature from the case we have just been looking at concerning the general regulations and how the Commission should approach its task in making those regulations. The authority of the judgment here only concerned the party which had appealed against the Commission's infringement finding. That is why Lady Justice Rose was absolutely correct in her analysis of it. Acid demand is a further illustration of how the control mechanism for the res judicata rule is the scope of the annulling judgment. If your lordships would turn in the bundle to page 1006, I will now look at certain paragraphs in acid demand, but I wish to point out there towards the foot of the page, just above the opinion of Mr. Advocate General Ruiz Jarabo Colombe, you will see the language of the proceedings, my lords, was English. So in answer to Lord Briggs's query earlier, whatever Servier's counsel was checking, the language of this case was English. Now, if we go further to the opinion of the Advocate General and turn to page 1026, the Advocate General says in a succinct paragraph 71, there is no doubt that as correctly observed by the Court of First Instance, the judgment of March 1993 annulled the first paragraph of Article 1 of the Woodpulp decision on the basis of considerations which are generally applicable to analysis of the woodpulp market carried out by the Commission at an earlier stage, which are not based on an examination of individual conduct or practices engaged in by each of the addressees. So there really can be no doubt that Servier's point in its written case is incorrect. If you go forward into the judgment itself on page 1040, paragraph 28, recording the Court of First Instance ruling, the individual decisions adopted in relation to the respondents were based on the same findings of fact and the same economic and legal analyses as those declared invalid by the judgment. So whatever this case was, it was not a case about different findings of fact. The Court of Justice's analysis, for present purposes, begins at the foot of page 1043 under the heading Findings of the Court in paragraph 49. And if you turn over the page to page 1044, paragraph 50 situates the problem before the court in line with the other cases that we've been considering as one where the court was concerned with the scope of the duty on the Commission to rectify matters following an annulment judgment. Paragraph 53 makes the point that this annulment decision in its scope only concerned the applicant, and that was the platform for the crucial reasoning in paragraphs 54 and 55 which follow. We've now seen these paragraphs already, but paragraph 54, I lay emphasis on the final words, cannot entail annulment of an act not challenged before the community judicature, but alleged to be vitiated by the same illegality. In other words, the control mechanism for the scope of the principle being applied is again, what is the scope of the annulment judgment? And in this case, it only extended to the party which had appealed. The point is then driven home in the following paragraph 55 in the plainest language, where it says the only purpose of considering the grounds of the judgment, which set out the precise reasons for the illegality, is to determine the exact meaning of the ruling in the operative part of the judgment. And in that light, you have the sentence that the authority of a ground of a judgment annulling a measure can't apply to the situation of persons who are not parties to those proceedings, and with regard to whom the judgment cannot therefore have decided anything whatsoever. That is because in that case, in that context, parties who were not parties to those proceedings were not the subject of the annulling judgment. And what these paragraphs therefore do is decisively to contradict Servier's argument that the grounds of the annulment judgment can be separated from the issue dealt with by the annulment judgment. It reaffirms the point I made a moment ago in relation to Asteris. The grounds only matter because they are a guide to the interpretation of the operative part of the judgment. And here the court says that is the only purpose for which one looks to the grounds. 56 rounds off the conclusion to the point. Now, there are two other observations that I would wish to make about this judgment. The point about time limits and the need to respect time limits, which Ms. Bacon rightly also refers to as an aspect of this judgment, is then picked up in the following set of paragraphs, paragraphs 54 and following. That further point does not affect the clear reasoning and statement of the law in paragraphs 54 and 55 concerning the res judicata doctrine. And finally, there is one other point to be gathered from this case. If you go to page 1046 and look at paragraphs 66 to 68, those concern another case, a venerable case from 1959 called Snoopat. And in paragraph 66, the court records that in Snoopat, there were very particular circumstances which led the court there to place an extensive interpretation on the obligation of the EU institution to take steps to comply with the annulling judgment. Paragraph 67 outlines essentially the situation. This organisation, Snoopat, had challenged a decision requiring it to contribute to an industry equalisation fund. And it complained that two other producers of ferrous scrap had been exempted from the need to contribute. It failed. But then Snoopat said that the high authority, the equivalent of the Commission, should respond to the court's ruling in its own case, saying that it failed, by going on to remove exemptions which had been granted to its two rival producers. If you read from 5 lines down in that paragraph, Snoopat then asked the high authority to revoke with retroactive effect the exemptions granted to the two other producers before finally bringing a new action which was eventually upheld before the court against the high authority's decision to refuse to accede to the second request. Then paragraph 68, which you see at the top of page 1047, is key because in a way it is echoing the later case which has been discussed in these proceedings of Orlando Perez Diaz, one of Servier's new authorities introduced in this court. it says that the exemptions granted to the two other producers were directly prejudicial to Snoopat, owing to the nature of the equalisation system which had been established, since they reduced the other two producers' production costs and increased Snoopat's, because the exemptions led to its own contribution being re-evaluated. And the court goes on to say this didn't happen to the fines imposed on the various addressees of the wood pulp decision, since the annulment of some of the fines didn't affect the amount of the fines which hadn't been challenged. My lords, that is an example, therefore, of a case where, in order to take remedial action, the Commission, in that case the high authority, needs to do something which necessarily is entangled with an impact on the applicant in question and can affect them. The next case in the sequence is the P&O Ferries case of June 2006. And Lady Justice Rose said at paragraph 30 of her judgment that P&O Ferries is the principal judgment dealing with the absolute res judicata rule. That is how Servier presented the case below, and its common ground. Ms. Bacon has correctly distilled the facts. When the appeal came before the Advocate General in February 2006, complaining about the Commission's decision a second time, the Advocate General outlined what it was that the res judicata doctrine attaches to. And I would wish to take the court to what he said. Those happen to be the same paragraphs that Miss Bacon touched on too. It's on page 1126. And we turn in the first column, bottom of the page, to paragraph 71. Here, the Advocate General discusses the distinction between subject matter, as it had previously been understood, and the real point that should apply in an absolute res judicata case, namely getting at the underlying point being decided in the operative part of the judgment. He says in paragraph 71, I must point out that the term same subject matter can't be restricted so as to mean two claims which are entirely identical. And in this case, it can't be restricted to the identity of the act that has been appealed, because the issue is not so much the identity of the act, but rather that of the points of law before the court. And then he says, importantly, it is on that issue that a judgment will be given and the force of res judicata will apply. And that is the principle that we say is right, and which this court then follows through in the judgment, as we will see. Similarly, if you look at the right-hand column on this page, in paragraph 73, and read there, in both the cases that are relevant here, the dispute appeared to be substantially identical. As in BAI, in fact, in the new proceedings too, the subject matter of the obligation was clearly the validity of the specific and different in the two cases Commission decision submitted for assessment by the court. However, the point of law actually at issue in the case, in both cases, the one which I believe became res judicata was the assessment the Commission had made of the measure at issue, in determining both cases whether or not the agreement constituted state aid. So the Advocate General is here referring to the underlying point at issue as being the gist of what becomes res judicata, and not requiring identity of the legal act which was challenged in two separate cases. With that, we come to the judgment of the court itself of June 2006. The key paragraphs are on page 1168. In paragraph 41, as I said at the outset, the key to this is the final sentence. The judgment was invested with the force of res judicata with absolute effect and prevented legal questions which it had already settled from being referred to the Court of First Instance for re-examination. And that is the central statement of what it is that the res judicata rule attaches to. It's the legal question settled by the court in the operative part of the judgment. Paragraph 43 refers to the annulment leading retroactively to the disappearance of the earlier decision with regard to all persons. That is what gives it the authority erga omnes and the force of res judicata with absolute effect. Again, the focus is on the authority of the court's order, which applies erga omnes. And finally, in paragraph 44, you have the paragraph explaining the function of the ratio decidendi in relation to the absolute res judicata rule. It relies on two authorities, both of which we have now seen, Asteris and Acidaman. And it similarly makes clear that the ratio is not separable from the operative part. Servier is therefore wrong in claiming that the underlying findings of fact in an annulment judgment can be separated from the operative part for the purpose of treating them independently as res judicata. And our submission is that the leading cases leave no doubt as to what the rule is about. That takes me to what was going to be a fuller second point in my submissions, namely that the Court of Appeal did not misunderstand the Acidaman case. Servier, in its written case, argued that the interpretation it had given to Acidaman, that it had been concerned with different findings of fact from the earlier judgment, had been confirmed by a later case called Tompkins, decided in January 2013. That is in Servier's written case at paragraph 51. Servier says there that in Tompkins, the Court of Justice in its reasoning regarded Acidaman as a case where the findings made in the earlier judgment were similar to, but distinct from, the findings of fact concerning the applicant in the case at hand. And as a result, it says in the written case, the court in Tompkins perceived that Acidaman had been trying to reason by analogy from different facts found in the earlier case. According to Servier, in Tompkins, both the previous annulling judgment and the case at hand concerned precisely one and the same facts, and that was different from Acidaman. Now, Servier's submission on Tompkins and the view that the Court of Justice took of Acidaman is incorrect. We rely for that on our written case, and what we said in paragraph 69, in view of the fact that it wasn't dealt with in oral submissions. I don't propose to deal with it in any detail now. I will merely say that in a nutshell, the court's holding there was that where the legal responsibility of two companies, a parent and a subsidiary, is interdependent in law, the parent, which has also appealed against an infringement decision, can take the benefit of an annulment granted to the subsidiary. It's a different sort of case. I turn then to the second of the new authorities introduced in this court, Orlando Perez-Diaz, which was addressed in the oral submissions. Servier says in its written case that Perez-Diaz is a further illustration of the same point as Tompkins. In the final sentence of paragraph 55 of their written case, Servier says that it is an illustration that the treatment of factual findings as res judicata doesn't depend on whether the findings are being borrowed from one context to another. The submission is incorrect because Orlando Perez-Diaz was also a case where correction of the error found found in the earlier judgment, the annulling judgment, necessarily involved dealing with the case of Perez-Diaz too. And if the court would please turn up Perez-Diaz, beginning at page 1536 for the English translation of the appeal. The facts of the case appear from the first 11 paragraphs, beginning on page 1537. In brief, the Commission organised the selection test to recruit 60 temporary staff, and the top 60 candidates in the process achieved scores of at least 144 points. That's paragraph 2. Mr. Diaz challenged this because one of the examiners didn't have a good enough grasp of Spanish to be able to assess his technical knowledge. That's paragraph 4. But the two other challengers, Sabag and Bachate, successfully challenged the process on different grounds, you see from paragraph 5, which was that the panel had fluctuated between different candidates and the arrangements for carrying out a fair comparison were generally flawed. You see from paragraphs 7 to 8 that Mr. Diaz was then invited to a new examination, which took place before 4 people. In paragraph 9, you see that the results he was given for the new test were viewed as insufficient because he only got a score of 141, and that was compared against the minimum score of 144, which had been achieved in the flawed first round by the 60 successful candidates. And it was that rejection that Mr. Diaz challenged. The relevant issue was simply whether he could rely on the findings of unfairness of the entire procedure, which had been determined in the annulling judgment in the cases of Sabag and Bachate. The basis of the court's reasoning again concerned the same treaty provision requiring the Commission to take the necessary measures to comply with an earlier judgment. And now it's called Article 233 of the EC Treaty, and you see that from paragraph 46 on page 1542, near the bottom of the page, the paragraph second from the bottom. The court did not mean to suggest, therefore, that the grounds had any independent legal force from the court's annulment declaration. On the contrary, if you look at paragraph 50 on the following page, 1543, near the top, the court recalled that the function of the grounds constituting the necessary support for the operative part is that these reveal the exact reasons for the illegality found in the operative part, and which the institution concerned must take into consideration when replacing the annulled act. The steps which the Commission had to take in this case to comply with the annulling judgment involved necessarily redoing their selection process. And you see in paragraph 48 at the top of that page, 1543, that the Commission frankly accepted that. Paragraph 53 on that page, 1543, the court explains here that it's the comparative assessment of the merits of all the candidates that was vitiated by the fluctuation of the composition of the panel and the spread of tests over several weeks. That point about it being interrelated and comparative in nature is amplified on the previous page at the foot, paragraph 47, the bottom of page 1542. The court points out there too that the defect to be gathered from the earlier judgments was that the selection process didn't allow a fair comparison of the merits of all the candidates. And then you come to the key part of the reasoning in paragraph 57, which is at the top of page 1544. That is where the court says, in those circumstances, the Commission couldn't legally, in order for the above-mentioned annulment decisions to meet the requirements of Article 233 reopened the censured selection procedure for the benefit of the excluded candidates by reproducing the conditions of conduct of the initial oral test, and so on. To sum up then, the reference which you get in paragraph 60 in the middle of that page, 1544, to the res judicata attaching to the grounds constituting the necessary support doesn't show that factual findings in the grounds is being lifted out and treated as res judicata in proceedings which have a distinct legal context. That is because the case was all about what the Commission needed to do to remedy the essential problem before it, which had been identified in the earlier annulling judgment. This has no bearing on what Servier wants to do in the case now before the Supreme Court. This is precisely the point that Lady Justice Rose made in the first 10 lines of paragraph 72 of her judgment below on page 189, which I simply draw to the court's attention, and in the interest of time, I shan't read. She pointed out there that the purpose they seek to rely on these findings for is completely different. I turn then to my third submission. The case law doesn't show that subsidiary findings in an annulment judgment fall to be relied on in a different legal context, only provided it is within the scope of EU law, the control mechanism suggested by Servier. Servier is wrong to say that. And in the questioning on this point this morning from Lord Lloyd Jones, it was suggested that if the proceedings, the case as a whole, includes an EU law issue, then it will bind even in relation to the domestic law issue in the case. So the interpretation being given, we see, to this control mechanism of within the scope of EU law is not merely referring to the issue at hand. The contention is that if the case as a whole has a point within the scope of EU law, then these findings in the annulment judgment will have res judicata force on every issue in the case, even the domestic law issues. Servier relies for this proposition as being arguable in its written case on the authority of Artigodan, the judgment of April 2012, which you saw this morning. The way that this is put in Servier's written case is again shown in paragraph 80D in its summary of key principles derived from the authorities, and that is on page 97 of the bundle near the foot of the page. Servier says there at letter D, although the effect of the res judicata is most commonly raised in the context of an EU institution taking a fresh decision to implement the judgment, so on, it is not limited to that context. The effect operates erga omnes in any case within the scope of EU law, including in damages claims as in Artegodan. The court judgment in Artegodan, which I invite the court to turn to, begins at page 1208 in the bundle. Artegodan was a case in which you had a judgment by the Court of Justice upholding the annulment of an act of the Commission, and it was followed by a claim for damages against the Commission in respect of the loss and damage caused by its unlawful act. The issue was whether in the claim the Commission was free to argue that its act hadn't been unlawful in a particular respect because the higher court had not ruled on that aspect. The lower court had done so, but that hadn't been addressed by the higher court. The first paragraphs to look at are the ones that Miss Bacon said were critical. At the foot of page 1220, paragraphs 86 and 87. The Court of Justice explains at paragraph 86 the function of the res judicata doctrine in general terms. Its role is to help ensure that judicial decisions, the term used, which have become definitive after all rights of appeal have been exhausted or all time limits for challenge have expired, can no longer be called into question. So the emphasis again is on the judicial decision, and that is equivalent to the point of law, the legal question which has been settled. This was the gist of what was at stake in this case. The focus was on preserving the authority of a judicial decision which had been reached in the earlier proceedings and which had by then become definitive. Paragraph 87 then goes on to say, in that regard, res judicata extends only to the matters of fact and law actually or necessarily settled by the judicial decision in question, and that the force of res judicata attaches to the operative part and the ratio which is inseparable from it. And so there is nothing here to suggest that underlying findings of fact leading to the earlier judicial decision can be separated from the judicial decision and regarded in their own right as res judicata in a different context. Nor is there anything in Artegadan to support Servier's proposition that underlying findings of fact will become res judicata with absolute effect in any other legal context, provided it falls within its articulation within the scope of EU law. The position in this case, Artegadan, was that the litigant was relying for its damages claim on the authority of the legal question that had been definitively settled in the annulment decision of the European Court. And the only issue in the case was what that entailed. Paragraph 88, the top of page 1221, the court said the doctrine required one to consult the judgment given by the higher court alone, not the lower judgment of the General Court. With that, I turn to my fourth point, the submission that it's not correct that any findings which can be regarded as the necessary support for the operative part of the annulment judgment will be binding in subsequent litigation. On that account alone. Here, Servier relies principally on two matters: the case of shoe branding, 2018, and the claim that this is the practice adopted in the context where national courts are applying the European Treaty competition rules in follow-on damages claims based on a public law infringement decision of the Commission. The main point appears to be the reliance on shoe branding. Servier says that shoe branding shows that findings in an annulment judgment, which are the necessary support for the judicial decision, are invested with the authority of res judicata on a freestanding basis. That is the proposition in paragraph 72 of its written case, after 4 pages of detailed discussion of the shoe branding facts. The health authorities agree that in a case where the res judicata principle properly applies, the principle will extend to findings that are the necessary support for the annulling judgment. But the point which stands in Servier's way is the premise. You have to have a case where the res judicata principle applies. And such a case will be one where the aim is to determine the exact meaning and implications of the operative part of an annulling judgment so that it's respected. In shoe branding, the res judicata rule did apply because that was precisely what was happening. Lady Justice Rose emphasised rightly in paragraph 69 of her judgment that the factual findings at stake, which was whether relevant consumers buying sports shoes had only an average degree of attention, wasn't being relied on in isolation in a different legal context. No, on the contrary, it was being relied on by shoe branding in an attempt to reopen the very issue that had been settled in Adidas's favour in that case, in the annulment judgment. And that is because the finding was key to the General Court's ruling that there was similarity between the two trademarks at issue, 2 stripes and 3 stripes on a shoe. And therefore, it's annulment of the board's previous assessment against Adidas. And if you turn up the General Court judgment in shoe branding, I will take this quite briskly. It begins at 1237. On page 1239, you see paragraph 13, that by a judgment in May 2015, the General Court annulled the board's decision against Adidas on the ground that the board had wrongly concluded that there was no similarity whatsoever between the marks at issue. And that had distorted the board's assessment. Paragraph 15, the General Court's order was upheld by the Court of Justice and became definitive. And then in paragraph 16 and 17, the board takes steps to comply with the annulling judgment. It looks at the case again, and now it upholds Adidas's appeal on the basis that there is a degree of similarity between the marks at issue. It is following the conclusion of the General Court on the point. Paragraph 18, shoe branding now appeals against that decision of the board. With that, if you go forward, please, to page 1249, you have paragraph 95. The first complaint being made by shoe branding is that the board should have found that consumers displayed a high degree of attention. You go to paragraph 100 near the foot of the page, you see that the General Court's judgment was that the board had been wrong first time around in its assessment of the similarity of the marks. Similarity was a necessary ingredient of the legal test under the relevant regulation. The General Court's conclusion on similarity had been based on 2 cumulative facts. Number 1, that sports shoes were everyday consumer goods. And number 2, that the relevant public only had an average degree of attention when buying those sorts of goods, not a high degree of attention. And therefore, shoe branding's argument was directed at undermining the assessment of similarity between these 2 marks, the very basis for reaching the legal conclusion in the operative part of the annulment judgment. Paragraph 101 at the foot of the page repeats the relevant test that the authority of res judicata attaches to the ratio, which is not only the necessary underpinning, but also, and again, inseparable from it. And then paragraph 102 at the top of page 1250, the board had a statutory duty to take the measures necessary to comply with the annulling judgment. In doing so, the previous paragraph 101 recalls that it's necessary to take account of the ratio of the judgment as well as essentially the declaration and order which constitute the operative part. 103 and 104 fall to be read together. The issue of the degree of attention paid by the public was the necessary support for the General Court's conclusion that the board had erred. And in following that, the board effectively and fully complied with the General Court's annulling judgment. You have essentially the same analysis of the point which, by myself, that Lady Justice Rose advanced in a condensed fashion in paragraph 69 of her judgment below. That is on page 188 in the bundle. Lady Justice Rose took the view that one couldn't detach the finding about the degree of attention of the public when buying sports shoes and then deploy it as res judicata in a different legal context if it could be said to fall within the scope of EU law. So I won't read it, but the relevant part to pick up the thread is 7 lines from the bottom of paragraph 69 in Lady Justice Rose's judgment, where she makes the point that I am now seeking to articulate. To sum up, shoe branding doesn't support the proposition that any finding in an annulment judgment can be separated and treated as binding, provided only that the finding is the necessary support for the operative part. That brings me to the analogy drawn by Servier. I put shoe branding to one side. She says that an analogy can be drawn, Ms. Bacon, with the context of national courts applying the European competition rules in claims for damages which are based on prior Commission infringement decisions. Servier argues that the national courts in that context delve deep into the grounds of European Commission infringement decisions, and they will there treat as binding in the litigation anything which is the necessary support for the Commission's decision of infringement. We agree that in a damages claim, the High Court, which is piggybacking on a Commission infringement decision concerning a particular agreement or restricted practice, is a context where the High Court aligns itself with the Commission on the details of how that agreement or practice was found to have taken effect. The High Court does that because it has been made responsible under the community law regime for applying the community's competition rules to agreements and practices alongside the Commission and to complement the Commission's work. The way it's often put is that the Commission's public enforcement work is complemented by the private enforcement work by national courts in respect of the self-same agreement or practices, and that there is a system of parallel powers. I shan't spend much time on it, but you see this from the foundational European regulation, Regulation 1. You have that if you go in the bundle to page 892. That is the first page. And I ask you to turn over leaf, please, to page 893. You'll see from recital 7, national courts have an essential part to play in applying the community competition rules. When deciding disputes between private individuals, they protect the subjective rights under community law. The role of the national courts here complements that of the competition authorities. They should therefore be allowed to apply Articles 81 and 82, which is now 101 and 102 of the treaty, in full. And if you go forward to page 895, recital 21, look at the first 2 sentences, you will see there the emphasis on consistency in the application of the competition rules. And recital 22 at the top of page 896 refers to the uniform application of the rules in a system of parallel powers. In recognition of the principle of consistent application, where a damages court is considering one and the same practice or agreement as the Commission has done, then the damages court will respect the grounds of the Commission's decision, which are the necessary support. But there are 2 important qualifications. The first is the point we mentioned in our written case at paragraph 122. The tribunal in the recent Trucks judgment that Miss Bacon referred to pointed out at paragraph 60 that a ground of a Commission decision won't constitute the necessary support for the operative part if you have other recitals which substantiate the conclusion. Reference essentially to a multifactorial assessment. The second qualification is far more important, and that is the principle laid down trenchantly in the House of Lords by Lords Bingham and Hoffman in the Crean litigation in 2006. The requirement that a national court should follow a finding of fact by the Commission, even if it's directly relevant to the case before it, only applies if the national court is dealing with the very same issue, the very same agreement or practice. Crean is in your bundles at page 1974. I've set out the relevant extracts from their lordships' judgment in our written case, but you find the relevant statements of Lord Bingham in that case at paragraph 11, and Lord Hoffman, if you go in the bundle to page 1996 under letter B, he sets out there the relevant article of the regulation, Regulation 1, and says at paragraph 64 that it only applies if the national court is assessing the legality of the very same agreement, decisional practice which the Commission has done. And then at page 1998, the top letter A, within paragraph 69, you have the prose which we extracted in our written case, that it is for the national court to refer to the evidence before it to reach its own judicial decision. And therefore, to sum up this point, the practice followed by national courts in follow-on damages cases doesn't show that the grounds of a Commission decision will be regarded as binding in a different context, nor does it show that a liberal approach is taken to determining what constitutes the necessary support for the operative part of a Commission decision. Now, Ms. Bacon has very helpfully said that she doesn't rely on the French law issues raised in her case in any detail, and I shall therefore not deal with those. I'll turn directly to my fifth and final submission here, which is that Servier's attack on Lady Justice Rose's finding that its approach has no workable limits and raises a host of practical difficulties is wrong. Servier makes essentially 3 points. They say it's not difficult to identify findings which are essential to the ultimate conclusions of the judgment. And if there is any doubt as to what is binding in a judgment such as the General Court's here, then you can simply send a question on the reference to the European Court. That's in their written case at paragraphs 95 and 97. Second, it's said that the 4 findings of fact on which they rely here are strictly limited to matters which were actually and necessarily decided in the annulling judgment. And third, they say that the workable control mechanism is to limit the doctrine to any proceedings falling within the scope of EU law, and that is entirely practical. We join issue with each of those contentions, and I'll deal with the first 2 of them together. So to take the proposition that it's not difficult to identify findings which are the necessary support for an annulment judgment, but if a national court is in doubt, it can simply send the matter off to Europe on a reference. The short answer is that this is completely impractical. It overlooks both the nature of a General Court judgment and the machinery of the preliminary reference procedure. So far as concerns the nature of these judgments, halfway down paragraph 72 of the Court of Appeal judgment on page 189 of the bundle, Lady Justice Rose referred to 2 particular practical difficulties. The first was touched on in the questioning earlier by my Lord Reid, and it is the difficulty in ascertaining the degree of granularity of the factual findings which actually fall within the scope of the res judicata doctrine. The second is Lady Justice Rose's observation that a very frequent feature of the general court judgments is that you have a number of facts relied on to support a particular conclusion, what an English court would call a multifactorial assessment. We gave in our written case an example of the Commission's survey providing support for the idea that prescribers widely regarded these different categories of drug as substitutable. My Lord Reed picked that up in questioning at the outset. Let me give one other brief example of the difficulties in this case. Servier sets out at paragraph 19 of its written case the 4 alleged findings of fact on which it relies, which it says are raised judicata erga omnes. Please turn up page 78 and look at D2 in her set of findings. The finding that treatment changes in patients undergoing continuous treatment were significant. In other words, the situation of people who are on long-term medication for their condition and how frequently the doctor will decide to change their treatment from one drug to another. Now go to the General Court judgment as the source for this factual finding. If you turn to page 812 in the bundle, that is within the General Court judgment, and go in it to paragraph 1544. This says, in the second line, it is true, treatment switching by continued use patients was significant. There you see the wording of the proposition which has been taken. I invite the court to go back one page to page 811 and look at paragraph 1540. 3 lines down, it says, it's apparent from the documents in the file that treatment switching of patients commencing treatment with perindopril is significant over a period of 5 years. But what does that mean? In turn, you need to go back again. And I invite the court to turn back to page 1524. I'm sorry, paragraph 1524 in the bundle. Paragraph 1524 is on page 808. This long paragraph describes the study which was the basis for those later statements. And you'll see it turns out that the 5-year study was dated October 2012 in the first line. So it doesn't relate to any time before 2007. 5 years prior to that. It therefore misses out the vast chunk of the period that our damages claims are interested in, which run from 2005. And equally importantly, and to chime with the point that was made earlier in relation to the Commission survey, if you look 6 lines up from the bottom, this paragraph shows that by significant treatment switching, it is referring only to a figure of something over 50%, not an overwhelming majority. My point, which I hope is self-evident, is that if you are interpreting these findings sought to be relied on by Servier, you cannot simply take those bland, broad propositions. All of this labyrinthine detail needs to be unpicked and looked into. And this also underscores the oddity of Servier's position, which we've drawn attention to in our written case at paragraph 35 and following. It is perfectly comprehensible to treat the ratio decidendi of an annulling judgment as binding in a case where you're trying to understand the scope or the consequences which follow from the operative part. But if you try to transpose findings like this, which are directed at an overview competition law inquiry into Servier's market power, into our damages context, where we are asking about whether prescribers and health authorities acted reasonably in their clinical judgment by having regard to the best interests of individual patients, it makes little sense, and it is extremely difficult to map it across in practice. It is like putting a cuckoo into the nest. It's likely to be productive only of confusion and, to be candid, many further rounds of litigation. And nor do we accept that each of these four findings of fact relied on by Servier are the necessary support for the General Court's final conclusion about the Commission's flaw in its definition of the product market. It is possible that the General Court might have reached that conclusion without reaching each of these findings, as we say in the written case. As respects the suitability of the preliminary reference procedure for dealing with all of this, my point is a short one. The sheer scale of the disputes that would be likely to arise across the Union would be likely to overload the Court of Justice. Lady Justice Rose was right to hold, in paragraph 73, the Court of Appeal, that Servier's approach is wide-ranging and unstable, without workable defined limits, and that it goes far beyond anything in the Court's jurisprudence. Now, my Lord, I'm conscious that I will need to break in order to confer with my colleagues for the Welsh and the Scottish and Northern Irish nations. Before I do, if I may, I will spend 5 minutes on the reference point and then ask the Court's indulgence for a short break to confer.
Yes.
In relation to a reference, there are two issues which arise. If your Lordships do consider that Servier have raised a point of European law which is arguable concerning the applicability here of the res judicata doctrine that must be settled in advance of the trial set down by Mr. Justice Roth. Those are whether a reference should be made at this juncture, and if so, what questions should be included. On the second point, what questions should be included, I would say now that we would wish to have a say that the current version proposed in paragraph 109 of Servier's written case completely ignores, for one thing, the distinction between Article 102, on which the annulling judgment was based, and Article 101, which is the basis on which the health services would continue with their damages claim, subject to a contrary decision by the higher court. On the first issue, which is whether a reference should be made by the Supreme Court at this juncture, we respectfully suggest that this is not necessary. It is not the course of action which best meets the needs of procedural economy and efficiency. It's common ground between the parties that the Commission's current appeal to the Court of Justice might result in all of the General Court's findings sought to be relied on by Servier disappearing. On one of the pleas in particular raised by the Commission, if the Commission succeeds, the entire analysis containing these four findings is likely to be annulled by the Court of Justice. In view of this possibility, that the General Court findings will be set aside, this court is entitled to decide that the right course to take is to await the Court of Justice's final judgment. It's hoped that that will be delivered in the course of 2021. The CJEU, the Court of Justice, discourages references that may turn out to be ineffective because the European law point isn't relevant in every eventuality to the decision in the main proceedings. And the point that is made there is an echo of Judge Lennox in his book on EU procedural law, which Servier has asked to be included in this court's bundle. You will find it in the bundle at page 2197 for the relevant proposition on which I rely. Turn please to page 2197. You should have paragraph 3.28. In Judge Lennox's book, the heading is National Court's Discretion. And if you look to the second full paragraph, you see if in one situation, the order for reference has to contain more than an exposition of the various factual and national legal premises or hypotheses underlying the case, together with the reasons for seeking the preliminary ruling. This is where it appears that union law isn't relevant in every eventuality to the decision in the main proceedings. In such a case, it's the National Court's task first to narrow down the legal debate to only those premises or hypotheses in which union law is relevant in any event. It goes on at the bottom of the page. The intention behind this restriction is to avoid a fruitless judgment from the court in the event that the National Court should subsequently find that union law has no part to play at all, having regard to the facts or the relevant national law. We say that the principle equally applies if union law is found to have no part to play at all because of a subsequent development such as that facing this court in this case, which is that the Court of Justice may overturn these findings of the General Court. If the Court of Justice does that, the res judicata contention will fall away, and the way is therefore cleared for the preliminary issues trial. If, by contrast, the Court of Justice upholds the General Court, in whole or in part, the parties and the court will then need to study the terms of the final decision, because it is only that decision which will have the effect of res judicata. At that stage, the English court may or may not be in a position to make its own reference to the Court of Justice. But if it is not, the post-Brexit position is that it will decide the point for itself. Finally, in relation to the authority of teleocenera that was mentioned by Miss Bacon, that is a case that takes the issue of a reference no further. The overriding point to be made there is that the case simply concerned whether a reference having been made by the National Court, the Court of Justice had to reject it. And that is a different question from the one facing this court, which is whether you should make the reference anyway in the present circumstances, given your view of the necessity of the issue. Turning to the detail, the actual issues that were being considered in teleocenera were different from the issues in this case. In that case, the court considered that there were two objections to the admissibility of the reference, and it rejected both of them. Was the reference admissible in circumstances where the facts had not yet been found? And a point raised by the Polish government as to whether the Court of Justice had jurisdiction if there was no effect on trade between member states. The key point in that case was that the National Court, under its own procedural rules, had to make a reference at that point without having found all the facts. That being done, the Court of Justice said, we're not going to reject it, and we consider it useful to decide the point. But the issue for this court is a different one. It is whether it conduces to the principle of procedural economy and efficiency if you agree that Servier has an arguable point that you should make a reference rather than awaiting the Court of Justice. My Lord, subject to conferring with my colleagues, those are my submissions. If I may, I would ask for a short break in order to do so, to see if there are any further points that I need to cover.
Yes, of course. Now, will 5 minutes be long enough?
I would ask for 10.
Yes. Yes, very well. We'll adjourn for 10 minutes in that case.
I'm obliged.
Mr. Turner, are you ready to resume?
Yes, thank you, my Lord. My Lord, I've conferred with my colleagues representing respectively the Scottish and Northern Ireland and Welsh Health Services. They have nothing further to add. And therefore, I come to my conclusion, which is simply that there is not in this case a relevant point of European law which is necessary to decide to enable the court to give judgment. Nothing should stand in the way of the trial which has been set down and which is ready to go in principle, and we invite the court to dismiss this appeal.
Thank you, Mr. Turner. Ms. Bacon.
My Lords, in reply, can I start with the headline point that Mr. Turner raised, and I will address that shortly, and then I will go through his main subsidiary points in response to our case. So the headline point is that the claimants rationalise the judgments that I've shown you around a limiting factor. And that limiting factor is that all of these cases concern cases where what was put in issue was the same subject matter as in the annulling judgment. And he set that out in his written case, and he's developed that orally. And he says that there's this further limiting factor which provides a connection between the res judicata, the point that is res judicata, and the original judgment, and which provides a link through all of the cases which I've shown you, despite their very different contexts and different facts. Now, the limiting factor that Mr. Turner relies on for the claimants, and that is developed in the claimant's case, is simply not set out in the judgments that establish the basic principle. P&O sets out the basic principle in quite clear terms, as does Artagodan in the passages that I've taken you to. It may be right that if the Court of Justice looked at this again, it would establish a further limiting factor, interpreting the principle of res judicata in the way that the claimants have said. It may be that they don't, and it might be that the court simply would restate the principle in the terms that it set out in P&O, in Artagodan, and in the other cases. But one way or the other, that's a matter for the court to decide, and it hasn't set out that limiting factor so far. Mr. Turner's submissions essentially rest on contextual points drawn from the particular cases that arose, but it doesn't, as I say, arise on the face of those judgments, including judgments of the Grand Chamber of the CJU. So that's the headline point. Now,
I'm sorry, I think the only Grand Chamber judgment we've looked at, I think, is
P&O.
no, P&O's the third chamber.
Yes, and I think that was the third chamber, but sitting in extended composition. I think that was it was a composition of 5. You're right, my lord.
Yes, I think Asteris is the only Grand Chamber decision.
Yeah, but one way or the other, the point that Mr. Turner makes in his overarching point about the res judicata only applying in context where what is put in issue is the same legal issue or the same legal context as arose in the annulling judgment. That is a point that is not expressed in any of the judgments. And indeed, as I've shown you in P&O, when that essential point was raised by the CFI, it was rejected in terms by the court. Now, turning to the specific points that he then went on to develop. The first point that he made was that findings of fact are not res judicata in their own right in a different legal context. And his explanation of the judgments on the meaning of a ratio are that grounds only really matter to explain the operative part, and they don't have independent life, if I could put it like that. They don't take separate and independent effect. The problem with that is that findings having independent effect, independent of the operative part and independent of the legal issue in the operative part, is precisely the point in Asteris. Because in Asteris, there was no debate about the operative part, and the legal question was not the one decided in the operative part. The operative part of the annulling judgment addressed squarely and solely the inequality that arose from the 1983-1984 regulation. But what was an issue in that case was whether that could extend to other years, later aid years, that were not the subject of that regulation, and which the court said in terms in paragraph 24 related to situations different from those governed by the annulled regulation. So the court was saying in terms, and that was actually one of the reasons why it rejected part of the Greek case at paragraph 24. The court was saying in terms that there was nothing wrong with the new regulation that had been adopted to replace the annulled regulation. What was wrong was the Commission's refusal to extend that to other years, which the court was saying related to situations different from those governed by the annulled regulation. And the fact that the case related to situations different from that addressed in the first judgment was squarely the ratio of the court's finding that that part of the Greek case was wrong, and was the reason why the court then had to go on to make the point at paragraph 27, which it did. So, having made the point about at paragraph 27 that one doesn't look at just the operative part but also the grounds, the specific point about the appropriate coefficients for the later years was analysed separately from the question of the operative part and what had to be done to give effect to the specific annulment judgment according to its operative part. In other words, the court was only able to find that the Commission had erred in refusing to act on the later years because it gave separate life to the ground in the finding about the coefficients leading to unequal treatment. So put shortly, the court could only decide in the way that it did by giving separate and independent life to the finding in the grounds, independent of the operative part of the annulled judgment. So Mr. Turner's opening proposition is contradicted by the very case on which he relies for that proposition. And that is the case which then sets the scene for P&O and P&O's concept of what is ratio. So having established from Asteris that the grounds of annulling judgment do and can have separate life, separate from the subject matter of that specific annulling judgment, that is the point that is then carried forward in P&O. And by the way, the same thing happens in P&O, because in P&O, having established what is the ratio at paragraph 46, and identified that the ratio for the annulling decision was, among other things, that the new agreement was not a normal commercial transaction. It is then that particular point that is then applied in the P&O case, independently of the annulling judgment itself, independently of the operative part, because the operative part of the annulling judgment simply said that the first commission decision was wrong and was annulled. And in order to then to extend that point into what the commission could then decide in a new decision, which, as the CFI said, was a separate subject matter, the court had to look at the grounds independently of the operative part. So that's the first point. The second point that Mr. Tanner made was about accidement. And his headline point in this, or one of the main points that he made, was that the findings made in the original wood pulp decision related not only to the applicants in that case, but also to the Swedish producers. And he suggested then on that basis that the reason why the Swedish producers lost was that they fell outside the scope of the operative part of wood pulp 2. And this was therefore an illustration of borrowing from one context to another. And his point on that is incorrect. And our written case, the way that we explained the judgment in our written case, was correct. The acid demand case, or the original wood pulp case, which was the annulling judgment, that concerned parallel pricing, as I'm sure you'll have seen. And the commission had found that the parallel pricing of all of the producers could only be explained by collusion. And that was in part based on a general inference from parallel behavior, but also in part based on the particular contemporaneous documents relevant to each individual producer. And the reference to that is in the CFI judgment, and that I don't ask you to turn that up. I'll just give you the reference. It's the CFI judgment at tab 4 of the bundle, paragraphs 82 to 84, and it's page 998. And that is why the Court of First Instance in this case expressed the point about the effect on the Swedish addressees tentatively. It said at paragraph 84, page 998 of the electronic bundle, that the wood pulp judgment had the potential to affect the Commission's findings relating to the Swedish addressees. And that potentiality argument is then repeated in paragraph 32 of the CJU judgment, which is on page 1041 of the electronic bundle. So the court was saying that the Commission's analysis of the position of the Swedish addressees was indeed very similar, and it turned on the same main inference as its case against the other addressees. But it remained the case that the CFI in the first case had not addressed the pricing behaviour or contemporaneous evidence of the Swedish producers at all. And that is specifically because of what the Advocate General referred to as the divisible nature of the decision. It's a bundle of different decisions. The CFR, the first judgment, the first annulling judgment, didn't specifically address all of the evidence against the Swedish producers. It addressed the approach taken using inferences from parallel conduct. But that didn't mean that it had, in effect, implicitly concluded anything about the non-appealing parties. And that is why the court reached the conclusion that it did at the end of paragraph 55 about the judgment not deciding anything whatever. The Swedish producers hadn't appealed. Their particular facts had not been the subject of scrutiny by the court that annulled the Commission decision for other appellants, and therefore the judgment had not decided anything whatever about the Swedish producers. And that was one of the strands. As I've said, the other strand was that in any event, the decision against them had become final because they hadn't appealed. And that point is made in the subsequent paragraphs, but also at the end of paragraph 54. It was an act not challenged before the community judicature. That's making the point about the decisions against the Swedish producers not being challenged, therefore became final. So that's Assi Demen. My lords, Mr. Turner then turned to P&O, and he extracted from P&O a particular point which fed into his initial overarching case about the relationship between the ratio and the operative part. And he attached great importance to the word inseparable, which appears in paragraph 44. Now, several points to make about that. Paragraph 44, as I've said, incorporates by reference asterisk. So what the court is doing is using the term ratio decidendi and referring to that there, and then explaining what it means by reference to asterisk. And as I've shown you, in asterisk, the court did separate and had to separate the ratio from the operative part, and that was the whole point of the case. What the court is saying, I think, when it uses the word inseparable in this context, is that you cannot just look at the operative part when you are deciding what you have to give effect to under the principle of res judicata, but you must also look at the grounds. And that's precisely what the court then proceeded to do in paragraph 46. It cannot have meant that you can only look at the grounds if you are looking at them alongside and as a means of explaining and surgically attached to the operative part, because that's not what it did in the following paragraphs. It did look at the grounds quite separately from the operative part, which, as I've said, only annulled the original decision and didn't say anything about the new decision. So the grounds, as was explained in asterisk, do explain the reasons for the operative part, and in that sense, they are inseparable. But the court was not, either in asterisk or in P&O, saying that on that basis, the reasons cannot have separate and independent legal effect. In any event, in the present case, the domestic court does have to give effect to the general court's judgment in its operative part. It cannot, as the Court of Appeal accepted, and as the claimants don't dispute, it cannot find that Servier infringed Article 102. So that's what the Court of Appeal found, and I gave you the references of paragraph 1771 of the Court of Appeal's judgment. So the question before you is whether giving effect to the general court's judgment stops there. And our position is that it doesn't. In the same way as in all of these cases, the court didn't stop at the operative part, but went further and applied the grounds to the issue before it. So in our submission, one doesn't just stop at saying that Servier cannot be alleged to have infringed Article 102, because that contradicts the operative part of the general court. What you have to do, as the court is making clear in P&O and asterisk, is also to take account of the rest. And that means taking account of the ratio. And the ratio indicates in our submission that there are consequences for some of the other parts of the case, in particular the damages arguments. So even on Mr. Turner's case, when he says you cannot separate the ratio and the operative part, but you have to look at them together, our submission is, well, yes, you are looking at them together. It is accepted in the domestic proceedings that the claimants cannot put in issue the Article 102 conclusion, because that's in the operative part of the annulling judgment. What we are saying is follow what the court has said in P&O and go further and also take account of the ratio. That's what the court said in P&O and also what the court said in asterisk, and that's what they did and had to do in those cases in order to reach the conclusions that they did. I don't think I need to say anything more about Perez-Diaz, Artagodan, and the shoe branding case. I've made my submissions about those in opening, and we've also dealt with them in detail in our written submissions. Can I then turn to trucks? And Mr. Turner's main response to trucks was to rely on the Korean case and the comments about not transposing from one decision to another. And there are two short answers to that. The first is that Korean was not dealing with annulling judgments. And I've already made the point in opening that we accept that there are different routes here to giving effect to commission decisions and court judgments. Commission decisions are dealt with under Article 16 of Regulation 1 of 2003. Korean was essentially the precursor to that as a matter of case law. But annulling judgments, as I've submitted, are distinct, and they have a specific legal route to their force binding effect in domestic law, and that is the principle of res judicata erga omnes, and Korean was not dealing with that at all. Secondly, in this case, we are not talking about, for example, two separate decisions concerning different parties. We are dealing with the same conduct. We're dealing with the same agreements that were at issue in the General Court, and a judgment concerning that one and the same decision that is being relied on in these proceedings. So even if there is a point to be made about the findings applicable to one decision not being transposed to another, that isn't our case. And in that sense, we're actually even closer than something like Asterisk, where you do have two completely different regulations, the regulations applicable for completely different aid years. That was one of the reasons why the court in Asterisk says that they were legally different situations. But here we do have one and the same commission decision that was the subject of the General Court's judgment and is being relied on by the claimants as a foundation of their damages case. Yes, Lord Sales.
Sorry, I was muted up to that point. Can I just ask you a question about Asterisk? I'm looking at bundle page 976, or indeed the previous page, 975.
Yes.
And forgive me, it's really going back to 974, describing the actions brought by the Hellenic Republic.
Yes.
So there'd been a ruling annulling a regulation for the 83-84 marketing year, as I understand it.
Yes.
And the Commission had put in place a new regulation for that marketing year to deal with the incorrect use of coefficients. But then it looks as though, as I understand it, the Hellenic Republic wanted to go both forwards and backwards. I'm looking at paragraph 24 now on page 975, because they wanted to have those coefficients applied for, I think, 81, 82 and 82, 83, the previous marketing years, as well as applied to the subsequent marketing years. And it looks then as though they had two ways of trying to achieve that. One was to attack the new regulation itself and have that annulled, presumably to make the Commission just start all over again and make that regulation apply more widely. And that failed because the new regulation, insofar as it dealt with 83-84, did address the problem. And then as an alternative, they complained that the Commission has refused to act and that there's an obligation under Article 176. And as I read this judgment, the court is very precise about the way in which the principle of res judicata applies in that situation. it says it can only apply with effect from, I'm looking at paragraph 30, the finding of illegality takes effect from the date on which the annulled measure entered into force. That was the 83-84 regulation, which was annulled. And so they say, well, the position as to the legality of use of coefficients is determined as from the first date when that regulation enters into force. And therefore, that finding will govern in relation to the subsequent years. But they're very, the court is very specific that it doesn't apply to the earlier years.
Yes.
And the reason for raising it is, it might not be said that that creates a difficulty for your theory of the res judicata doctrine in EU law, because why, if the error as to the coefficients was applicable generally, did the remedy granted not apply to the years prior to 83-84 as well as to the years subsequent?
Yes. So this is the background to this was all very complicated, and your lordship has described it almost exactly correctly. The one point of detail is that in the early part of your description is that, as far as I understand it, and I've also gone back to the original annulling judgment and have spent far too long trying to figure out what was going on in these cases. As far as I understand it, what happened was that rather than simply replacing the entirety of the regulation that had been attacked first time round, the operative part of the annulling judgment said it's unlawful insofar as the coefficients lead to the inequality. And in the grounds of the annulling judgment, the court had said, that it's for the commission then to decide how to give effect to this and how to sort out the problem, if you like. And the way that the commission sorted out the problem was not to replace the annulled regulation, or the regulation that had been partially annulled, actually, to be accurate. But it adopted this new regulation, which, as I explained, I think in opening, it sort of leveled up. It granted additional aid, but only to the Greek producers. So that's the one tweak to the description of what was happening. Now, the Advocate General thought that consequence applied not only to the 1983 year, 83-84 year, skipping a year, because the following regulations for the 1984-1985 year, it was out of time to do anything out of that. And then he thought it applied from the 1985-86 year going onwards. And he thought that was, slightly odd, but he drew that conclusion because the 1984-1985 regulation hadn't been applied, and so he thought that was final. He agreed that up until 1983-1984, because there'd been no challenge and it was then out of time to do anything about those couldn't be retrospectively corrected. Now, the court followed that reasoning in part, and it thought that the effect of the annulling judgment did have prospective effect. And it didn't take effect from for the previous years, and that's the point at paragraph 30. By virtue of the retroactive effect of judgments, the finding of illegality takes effect from the date on which the annulled measure entered into force. So the annulled measure had entered into force for the 1983-1984 year. The judgment could then only have effect from that point, so that the judgment was retroactive. So you go back to the point at which the annulled measure enters into force. That's in the first sentence of paragraph 30. And that meant that from that point onwards, the commission had to take account of the judgment, but it didn't have retroactive effect going back even further, because of the way retroactive effect is defined in community law, as I understand it. The retroactive effect in community law goes back to when the annulled measure enters into force, and so it applies from that point onwards. And the court thought that it then applies to all of the subsequent regulations, whether or not the Greek government was out of time to appeal them. So that's why the court differed from the Advocate General. It said it applied not only to 1983-84, but to all subsequent marketing years, whereas the Advocate General had based his view on when the regulations had become definitive, as in when it was out of time to challenge them. And so he said, you skip a year, and it's only 1983, 1984, skip a year, and then 85, 86, and so on after that. I'm sorry, that's a rather complicated explanation. Have I answered your question?
Well, thank you for that, but I'm still not quite sure whether you've addressed the point that I was trying to put to you. The Hellenic government was seeking to complain about the Commission's inactivity in relation to the previous marketing years. And they got a finding from the previous annulment provisions that the wrong coefficient had been applied, and that reasoning applied to the previous years equally. That was the burden of their complaint, that they wanted the Hellenic government to do something in relation to those previous years. The court, at paragraphs 30 and 31, says the principle of res judicata doesn't apply to take them back, enable the Hellenic government to go back to the earlier years with their complaint. It only applies very precisely from the point in time when there's been a determination of the illegality of the use of the coefficients, that is specifically from the inception of the 83-84 regulation.
Yes.
So the reason I was pressing you on it was, it seems to me, well, at the moment, that creates something of a difficulty for your theory that the principle of res judicata in EU law has some sort of freestanding basis aside from the very specific ruling in a particular annulment decision. If you can help me with that, that would be great.
So there are two different principles. There are two different issues at play here. So the first is why the res judicata didn't go back further than it did, and the court is simply saying, well, it all flows from that judgment. It all flows from the annulling judgment, and the annulling judgment can't have effect retroactively before the 1983-1984 year. So nothing that flows from the annulling judgment can have an effect for the earlier regulations, and that's the point in the first sentence of paragraph 30, and that's why the Commission wasn't then obliged to go back into eternity and correct every previous regulation that might have been tainted by the same irregularity. But there's a separate point about the independent life of the grounds, and the reason why I referred to asterisk for this point was that to explain that the annulling judgment itself was only related to that year, and so in order to give effect, if you only looked at the operative part, you could only have corrected that year, and the same point really applies incidentally to Perez-Diaz. Because the operative part in the judgments of Miss Bachete and Miss Sabag only applied to them, and that was a point that the court made in the paragraph that I said was strangely translated. But anyway, in asterisk, the annulling judgment, the operative part of that only addressed the 1983-1984 year. So the grounds had to be given independent effect, because it was only by giving the grounds independent effect and effectively divorcing those from the specific operative part that you then got to the point that subsequent aid years, which hadn't at all been even put in issue in the original judgment, nevertheless had to be corrected. They had to be leveled up.
Yes, thank you very much.
So, my lords, I was going to go on to deal with the point about workable limits, and Mr. Turner gave us an example of the problems that he said would arise in trying to extract the ratio. And I should first say that this isn't a problem that seems to have bothered the court too much in Trucks, where, as you will have seen from the Trucks judgment, the court made some quite high level and general findings, which are nevertheless binding. And that doesn't mean that if there are specific factual points raised in those cases that that don't contradict those findings, those specific factual points can't be made. But what the tribunal is saying is that the baseline is that having extracted these points from the ratio of the decision in Trucks, those are the findings that are binding on the court in the eventual trial that will take place, and that is for the parties to say what they like about the points, that the relevance of those, and whether there are further and better arguments that can be made on both sides. But the starting point is that you have this bedrock or baseline of findings that are binding on the court, and the Trucks judgment extracted various findings which are of a very high level of generality in terms of most people doing this, and in some cases that, and which are not at all of the degree of precision that Mr. Turner would seem to expect in this case. But leaving that aside, the majority of Mr. Turner's fire on this was directed at one of the findings that we have extracted. This is our fourth finding about treatment changes in patients undergoing continuous treatment being significant. And he made a point based on the general court's judgment, which I just want to go back to. Do
bear in mind, Ms. Bacon, you have very little time.
Oh, I'm sorry. Well, yes, I spend quite a lot of time responding to Lord Sales's comments, so I wanted to deal with that in detail. All I want to make about this is that the point that he took you to regarding the general court, he took you to one study that's referred to in paragraph 1524. In fact, at paragraph 1531 of the 1531 of the general court's judgment, what the court says, it's based not only on the KEGA-DIM study but also IMS health studies, and the IMS health studies are referred to at paragraph 1525, and it's clear that the IMS health study does cover the period 2003 to 2008, and the KEGA-DIM study, which he cited at paragraph 1524, covers the period 2005. We know that because that's referenced in that paragraph. Now, can I come on to the reference question? And can I just say a few things about that? Now, the bindingness question, as matters stands, falls to be decided before the trial. The trial cannot go ahead until the question is decided. Now, if your lordships agree that the point of law is not act clear, then the question is whether to refer now or whether to stay this appeal and await the CJU appeal judgment. And that's essentially a case management decision. And the CJU has made clear that it is in principle for the national court to decide the need and the relevance of questions referred to it. And that's paragraph 15 of Tellier-Sanera. The only question is then whether it is a hypothetical case. And Mr. Turner is right to say that hypothetical questions are discouraged. And he referred you to Lennox. But he referred you to Lennox for a proposition that where EU law itself may not be relevant, and where the question of whether union law is relevant at all is hypothetical. In that case, in that one situation, Lennox says, the order for reference has to determine the hypothesis. And what Lennox is doing in that part of the paragraph 3.28 is talking about the Mylicker case, where the court had said that the problem before it was entirely hypothetical, and the question of EU law, it wasn't at all clear whether that was relevant to it. But in this case, EU law is squarely engaged. There is no question about the question of EU law being hypothetical. EU law is relevant because the claimant's cases are brought under Articles 101 and 102. So this is not a question in which we don't know whether or not union law is relevant. The other point is that Tellier-Sanera makes clear that the hypothetical point is not engaged simply because some other issue might come up that would render the referred issue hypothetical. In that case, if it were necessary for the national court to have established all of the facts and matters which could have made the question relevant in that case, then Telius-Sonera would have been hypothetical. But the court says that it can answer the questions. And 10 questions were referred in that case on abuse in circumstances where the national court hadn't even found Telius-Sonera to be dominant. But the court says at paragraph 17, that didn't matter. The question is whether the questions referred may be required in order to enable the court to give a ruling. So to put the point another way, at the moment, the issue is not hypothetical. Mr. Turner's concern is that it might become hypothetical depending on what the CJU says. But that's not a ground for refusing to make a reference. And we don't see any hint in the CJ's judgments that the CJU would consider that a hypothetical case, because the point does arise now on the facts before the court. The other point I should make is that, as Mr. Turner acknowledged, and rightly so, the CJU proceedings are well advanced. So by the time that the court hears the reference, if it's made, it's very likely to have before it the CJU judgment. And in any event, the court can make this, the Court of Justice, when it receives the reference, can make a case management decision, if necessary, as to the sequencing of this reference and its judgment on the appeal in the Servier case, and it must know what the timing of that is likely to be. But ultimately, in our submission, it would be very odd for the highest court here to decide that something is acte claire on a point that is of potential relevance across the EU, but then to hold back and not make the reference at this point in time when we can make a reference, delaying the issue until potentially a reference can no longer be made, because the court would then itself be taking it upon itself to decide the question of case management and how to respond to the reference that is, in our submission, a matter for the CJU. Can I just check whether there's anything else I need to say?
Yes.
So just to wrap up, in our submission, whatever Mr. Turner may say about what might be the limits of the res judicata erga omnes principle, those limits are not set out in the court's case law. The issue, as we have said in our written case, cannot be said to be acte claire against us. If there are further limits to be introduced, that is a matter for the Court of Justice. On that basis, in our submission, the matter should be referred by this court, and it being not a hypothetical case, the court should refer it now, and we would very firmly submit that the very high threshold of whether a matter is acte claire is not met by Mr. Turner's submissions in this case. That the acte claire doctrine applies to questions that are said to be obvious, for which the answer is said to be very obvious. You can see that I will just give one reference that I've already given to Mr. Turner. I won't take you to it now, but just for your lordship's reference, the acte claire doctrine is set out in paragraph 3.54 of the Lennox text, which addresses the kill-fit formulation and comments that this involves a very limited category of extremely obvious questions of union law. In our submission, Mr. Turner's submissions don't come close to showing that his formulation of the res judicata doctrine is so obvious that this court can decide it for itself without making a reference. My lord, those are our submissions.
Can I just ask, I don't know if the parties are having a transcript of this hearing prepared. If you were, I was going to say it would be helpful if a copy could be provided to the court. But if you're not, it doesn't matter, obviously.
I am not aware of one.
That's fine.
No, I'm sorry, my lord.
No need to apologise. It just occurred to me this is the kind of case where sometimes parties do, but that's fine. Well, if there are no other questions, then let me thank both counsel and those who've assisted you in preparing your submissions. We'll take time to consider them now and let you have our judgment as quickly as we can. The court will adjourn.